way, but that's fine. I mean, right. Now, today's session is on human rights in global world. And it looks like that participants will be talking about human rights in globalization, I think, right? To my mind, I mean, there are many meanings of the term globalization, but there is one more aspect of the idea of globalization that is rarely seen, rarely pondered upon, and that is to say that the idea of, I mean, in the globalization now, the very idea of nation state is actually diluting. Now there is actually international division of labor everywhere in the world. Now there are capitalist economies also everywhere in the world, and we also see the world military order. Now, given these world hegemonic economies, I mean, the human rights movement faces so many challenges at the hands of the forces of capital, because these forces of capital actually try to reinforce imperialism, colonization, patriarchy, racial discrimination, and many such problems. I mean, right. So I hope that the participant will be dealing with such issues as well on the theme of human rights in global world. Thank you so much.
Thank you, sir. So I request the chairperson and the co-chairperson to give the permission to start the session.
Please.
Thank you, ma'am. Thank you, sir. So before starting the session, I would like to tell the rules to the participant that each and every participant will be given 5 minutes to give the presentation. And before giving the presentation, each and every participant, please introduce yourself as well as on which topic you are going to describe. And I request that each participant, there are a number of participants, and so I should ask himself to present the paper.
Thank you, sir. So can I have the request to send all the participants in the waiting room so that we could call each one of them?
Yes.
Thank you, sir.
Chairperson and co-chairperson, the first participant is P1 Lakshya Saini, research scholar. Lakshya Saini, he is the research scholar. Yes, Lakshya Saini, you can start your presentation and introduce to the chair and the co-chairperson.
Okay. Very good afternoon to the chairperson, Dr. V. Vishalakshi ma'am, and co-chair, Dr. Kailash Chinekar sir. So myself, Lakshya Saini, and I'm research scholar at Jawaharlal Nehru University, New Delhi. So I'm going to share my screen. Wait for a second. Actually, I'm unable to share it. Can I speak? Actually, I have prepared the presentation, PowerPoint presentation, but I'm not able to share it.
So you must be having the permission to share the screen. We have allowed it.
Yes.
So please take it once.
Okay.
You can go for the PPT also.
Okay, share screen. I have to select desktop one.
Please select the desktop which is showing your PPT.
I'm sorry, I'm not able. I will just speak. Okay, I'm not able to do this. Yeah.
Without PPT also you can present, no problem.
Okay. So my topic is a virtual curfew in India, study of socio-economic ramification of internet shutdowns. I will give a brief, before starting, I will give a brief outlook of how the evolution of freedom of speech and expression has been done in India over a period of time. The constituent member of our constitution makers incorporated this in the part 3 of the constitution in order to maintain the justiciability of rights. The question arises here why it was made constitutionally justiciable. It was made in part 3 in order to make constitutional justiciable, and in order to make less prone to dilution, and in order to make check and balance of parliamentary democracy in India. Freedom of speech and expression is also known as the mother of all liberties, because without the freedom of speech and expression, one is not able to assert his rights or his views or anything. It can be told to the world with the expression itself. Now coming to the concept of censorship and internet shutdown in India. Why and how the notion of censorship came into existence. Initially, in the Rome, the office of censor was incorporated, which was the office of censor was responsible for adjudication upon the matters of moral and ethical conduct. In Rome, the power of freedom of speech and expression was given only to the person who were either in power or in authority at particular that time. Initially, the censorship module was done upon books, plays, songs, pamphlets, and upon any form of other expressive art that was relevant at that particular time. Initially, whether it is in India or in any other country, the censorship module was enforced to maintain the status quo of religious or moral orthodoxy that was relevant at that particular time. Now coming to the issue of internet censorship and shutdown, the internet censorship and shutdown came into existence with the advent of the internet itself. It was basically implemented, the censorship and internet shutdown was basically implemented on the pretext of law and order issue, hate speech, morality, fake news, and public order. Regarding internet shutdown, before 2017, the internet shutdown or the internet blackout was done under section 144 of the CRPC, and there was no other legal equipment which could be ordered for the internet shutdown. So the magistrate had the power to impose internet shutdown in any particular area for a particular duration, for a particular period of time under the section 144 of the CRPC, and this gave the ample power to the magistrate of that particular area. But due to mounting criticism from international human rights and in India too, in 2017, there came new rules known as the Temporary Suspension of Telecom Service Rule 2017, which was made under the Section 5, Clause 2 of the Indian Telegraph Act. So these rules came into 2017, which provided for specific legislation for imposing the internet shutdown. Now, this Temporary Suspension of Telecom Service Rules 2017 gave power to the central and state home secretaries to impose shutdown. And earlier in section 144, there was no mandatory requirement for providing reason for internet shutdown. But this temporary suspension of telecom service rules provided that in particular order of internet shutdown, one has to provide reason order for his decision of his order of internet shutdown in particular area. The other important thing about this rules was 2017 that the order which was issued has to be forwarded to the review committee, and the review committee has to review that order within 5 days in compliance with the section 5(2) of the Indian Telegraph Act. Although in exceptional cases, order can be issued by an officer of the rank of Joint Secretary. The important thing here in this 2017 rule was in 2017, there was no specific mention of that how much time can be provided for the internet shutdown in the order. There was no limitation of the time limit for the imposing of internet shutdown. However, in 2020, these rules were amended again, and that rules provided that once an order has been imposed, that maximum internet shutdown can be imposed for up to 15 days only. Now coming to the question of the review committee, the constitution of review committee is as follows. The review committee to be constituted by the central government shall be consist of the following, namely the cabinet secretary as chairman, secretary of the government of India in charge, legal affairs as a member, secretary to the government department of telecommunication as a member. In case of state, the review committee to be constituted by state government shall consist of the following, namely chief secretary, chairman, secretary law, legal remembrancer in charge, legal affair as a member, secretary to the state government as a member. Now the important thing here in this constitution of the review committee is you must see that all the chairman and the other two members, they all are bureaucratic members, and the bureaucratic members are all the officials of the government of the day. So I don't know how they are going to review the order. Now coming to the jurisprudence of this internet shutdown, how the jurisprudence of internet shutdown has evolved over a certain period of time. So the first case was Gaurav Suresh Bhai Vyas versus State of Gujarat. In this case, Gaurav Suresh Bhai was a law student, and there was a ban of usage of internet services in the state of Gujarat. So Gaurav Bhai Suresh approached the state of Gujarat High Court by appropriating for the direction of appropriate rate, arguing that it has violated his Article 14, 19, and 21 of the Constitution of India. Although the government had power to impose restriction under the 69A of the Information Technology Act, but the High Court in this case observed that government of the day has the power to impose restriction or the internet shutdown in order to maintain the public safety or the public order of that particular area. The another case is Anuradha Bhasin versus Union of India. In this case, the petitioner Anuradha Bhasin contended before the Supreme Court that in the state of Jammu and Kashmir, after the application of Article 370, there was complete lockdown plus internet shutdown of the mobile internet services also and the landline also. So they
Lakshya, please conclude as soon as possible. You have last 1 minute.
Okay, sir. Okay. So, what does internet shutdown do in general? In majority of cases, it has been imposed as a preventive measure than a reactive measure, and in majority of the cases, it is affected the mobile internet services. The broadband services are usually not barred. The majority of the internet mobile service have been barred. Basically the three fundamental rights are violated by imposing of internet shutdown, Article 14, 19, and 21. Now coming to the effects of the internet shutdown, sociological effect or the economical effect. Internet shutdown or censorship also impacts the education sector, employment sector, banking sector. It also creates online societal segregation in the society. It also impairs the health services in the society. It also creates the information blackout in the society, apart from affecting small and large scale business online. Now coming to the conclusion, internet now closely is noted in social and economic cultural fabric of the global society. Apart from social and economic distress, network shutdowns also trigger psychological effect upon individual depending upon the location, duration, and social status of an individual. It may impact mental, emotional, and spiritual dimension of well-being of an individual. Although the data to trace the psychological impact of internet shutdown is quite scanty. The reason being is that in order to trace the psychological impact of internet shutdown, we need professionals for that purpose. The Constitution of Review Committee is purely bureaucratic in nature. So my suggestion would be the Review Committee should have a retired judge of High Court as a chairman of the committee. And the triangle of Article 14, 19, and 21 of the Constitution of India needs to be applied in its letter and spirit. Yeah, thank you.
Now, I would like to invite you. Abhishek, please introduce your topic. and you are invited to present yourself. You have been given 5 minutes and you can share your PPT also.
Sir, give him a minute. He is just joining. There's
Okay.
Sir, he is in the meeting.
Akshat, what was the topic? Yes, Abhishek Dwivedi, you may introduce yourself, introduce your topic.
Yeah, sir, am I audible and visible?
Yes.
Yeah. So good afternoon to the chairperson, co-chair, and to everyone else. Thank you very much for giving me this valuable opportunity to present my topic. I am Abhishek Dwivedi, and my topic of presentation is freedom of speech and expression and sedition. So, sir, shall I start?
Yes.
Yeah. So I would like to start my presentation with a very beautiful quote by Mahatma Gandhi, who said that speech is silver, silence is gold. But the silence of the educated people in present day scenario over an issue concerning the integrity and sovereignty of the state is harmful for the nation indeed. The right to freedom of speech and expression is considered essential for the survival of a democratic society. And when we talk about democracy, the right to speak freely is the first prerequisite that comes to our mind. The freedom to express one's opinion without threat, and particularly without any fear of repercussion, is very crucial for the growth of a nation. Freedom of speech and expression in the Indian scenario has been given under Article 19(1)(a) of the Constitution of India, and it is also included in the preamble, where the people are guaranteed the freedom of thoughts, expression, belief, faith, and worship. Considering the international scenario, there are several statutes which protect the right. Some of them are Article 19 of UDHR and ICCPR, Article 9 of African Charter on Human and People Rights, Article 10 of European Convention for the Protection of Human Rights and Fundamental Freedom, and Article 13 of American Convention on Human Rights. In the case of Keshwanand Bharti versus State of Kerala, Justice Jagmohan Reddy very rightly said that freedom of speech and expression is considered a basic structure of the Constitution. Therefore, the government cannot amend the Constitution to deprive people from their freedom of speech and expression. Moving forward to the concept of sedition, as I am assuming that we all know about sedition, so I'll cut it short. It is given under Section 124A of IPC, and sedition is a cognizable, non-compoundable, non-bailable tribal by court of session. And if we divide the definition of sedition, we'll get 3 points. The first, that it is a conduct either by spoken, written, or sign language. Second, it brings hatred, disaffection, or is contemptuous against the government. Third, it results in public disorder or imminent violence. Mahatma Gandhi termed sedition as prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. But unfortunately, as it is quite visible in today's scenario, this prince has grown up and now become the king. Moving forward to the constitutional validity of sedition and speech, democracy means government of the people, by the people, and for the people. So every citizen of the country is entitled to participate in the democratic process, and to make it transparent and free is very essential. It is one of the most important characteristics of democracy. The government is not above the people. It is the people who is above the government. So it makes the government inferior to the people. So the citizen should have a right to criticism, but the condition being is that a person should not break the law or encourage any form of strife. Democracy, as we are talking, can function in its best possible way only when the state and the citizens perform their duties and think first on the national level and then on an individual level. The government, it is very essential for the government to understand that affection cannot be manufactured or regulated by the law. If one has no affection for someone or something, one should be free to give the fullest expression to his disaffection, so long as he does not contemplate, promote, or incite to violence. Hence, the shoulder of those who are governing should be broad enough to accept reasonable criticism. Their thinking should be wide enough to accept the fact that there can be another point of view. Criticism of the policy of the government is not sedition unless it is a call for public disorder or incitement to violence. It has been very rightly pointed out in the case of S. Rangarajan versus P. Jagjeevan Ram that it is not required in a democracy for everyone to sing the same song. But from a people's perspective, we also need to understand that the power given to us, that is freedom of speech and expression, is very powerful. And as it is known to all that with great powers comes great responsibility, hence we also need to be responsible. The first time when the constitutional validity of sedition was challenged was in the case of Tara Singh Gopichand versus State of Punjab, where the Punjab High Court considered Section 124A as unconstitutional, as it contravenes the freedom of speech and expression provided by Article 19(1)(a). But the Parliament did not find it favorable, and it brought an amendment, that was the First Amendment Act 1951, amending Article 19. Then after that, the first constitutional challenge to Section 124A after the First Amendment was brought before the Patna High Court in the case of Devi Soren versus State of Bihar, wherein the court confirmed the constitutional validity of Section 124 vis-a-vis Article 19. Secondly, in the case of S.I. Singh versus a state, the Manipur High Court held that Section 124 of IPC was partially unconstitutional to the extent it sought to impose restriction on freedom of speech insofar as a speech merely excites or tends to excite disaffection against the government. Thirdly, in the case of Ramanandan versus State of Uttar Pradesh, the Honorable Court stated that Section 124 of IPC is unconstitutional and is highly questionable and undesirable, and it should be repealed as soon as possible. So what the Supreme Court did in the case of Kedarnath versus State of Bihar, it clubbed all the three cases and decided that Section 124A of the Indian Penal Code is constitutional, but also stated that this section must be carefully interpreted, and if given wider interpretation, it would not pass the test of constitutionality. The Supreme Court in this case made it very clear that the difference between unfaithfulness towards the government and commenting upon the action or the work of government without the intention of creating public order is very different.
Abhishek, conclude your
Yes, sir. Yes, sir. Just concluding. Yes, sir. In the year 2021, there was again a case filed, that is Kishore Chand versus Union of India, wherein three-judge bench considered all this. Three-judge bench issued a notice to the central government concerning the plea and agreeing to examine the validity of Section 124A of IPC, and it is still pending. And to sum it up, I would like to state a quote by George Orwell, who said that if liberty means anything at all, it means that the right to tell people what they do not want to hear, and not that what they want to hear. Which means that if you tell me that if I am a great author and I would let you say that does not mean liberty. You enjoy liberty only if you tell me that something is not correct in me, and then I allow it. So even if in that scenario, if I am tolerant, even if I have the power to quash it, I let you express your opinion, and it is genuine democracy if I, however powerful I may be, cannot hurt you for the nasty things you say about me, because the law protects you. Thank you.
Thank you, Abhishek. Dwivedi ji. Now I call Manish Singh and Dr. Varsha Bavja. Manish Singh is the PhD research scholar, and Varsha Bavja is the professor. I invite them to present their topic as the research paper. Please.
Good morning. Good afternoon, everybody. My name is Mannat Singh.
Oh, sorry, Mannat Singh.
Yes. So I'm a scholar, research scholar, and I'm also teaching at IP University. So the topic for my paper is regarding privacy rights vis-a-vis forensic methods in Indian criminal justice system. So like Edmund Lockhart said that, wherever there is a contact, there will be an evidence for sure. And which is why forensics becomes extremely crucial, inevitable for our criminal justice system, where we are failing highly in India specifically. In 99% of the cases, we do not use forensics, as we do not even have the basic equipment for us to test and analyze a criminal scene while there exists one. And when we talk about globalization, it becomes a crucial feature of a contemporary society. And globalization, with globalization, there are different challenges and therefore different kinds of crimes and therefore different sort of issues that come up, which need to be dealt with very intelligently and with the new systems that are prevailing, technological systems that are prevailing in the society. Now, technological advancements that have been made in the criminal justice system to make the investigation easier. Searching and interpreting some evidence has become, and addressing its reliability is also very important. We believe, bahut baar, we say that forensics is basically 100% true, but that's not so. For a lawyer to understand the importance of forensics, that how does a forensic system work, how can we interpret and analyze any evidence, and whether if we are interpreting it, what is the reliability? How many cases have we heard where there has been a lawyer has questioned the reliability of a forensic test? It doesn't exist in India. We don't have a single case. I could not find a single case where we had challenged the reliability of a forensic evidence. Now, when we talk about DNA testing that I focused on mainly, DNA fingerprinting or DNA profiling in court system is used to link suspects to biological evidences and also to establish paternity in custody and child support litigation. Here the question arises, which is regarding privacy. Can anybody be forced to give a DNA evidence? And a person who has probably or not indulged into an extramarital relation be asked to give a DNA test in order to determine the paternity of a child? And because and also, if we test the paternity and it turns out to be wrong, we have to understand that it creates a lot of more issues. The legitimacy of the child is in question, and we are questioning the whole lot of we are actually creating trouble for the child per se. Now, DNA, how does it work and whatever I've already mentioned in the paper, but I wouldn't go into that because our field is more talking about law. I wouldn't talk about the scientific evidences and how it works, how it is done. I think people who are experts of this would probably have the knowledge of how DNA testing works. Now, DNA testing in general in courts are usually not done in common course of the day. And that the court as a rule does not grant application directing any party to undergo the DNA testing. And paternity being a very sensitive question, there are diametrically opposite viewpoints for the same. Now, Section 112 of Indian Evidence Act says that if a birth is done during a marriage, it is a conclusive proof of legitimacy. Now, when we talk about conclusive proof, can we not, can there be no doubt? How can there be no space for doubt? And if there is space, how can there be a conclusive proof for the same? But in many cases, the courts have said that no person can be pushed to take up any blood test or DNA test, either in a criminal case or a civil case, even if the subject has given consent to it. It must amount to unwanted intrusion into the personal liberty. However, this is not the case in USA. When we talk about the US system, we have to see that they have a system in Amendment 4 where they talk about seizure and seizures and how to seize. They seize any, they consider the seizure as allowable only when it is not intrusive, and if somebody has put apart any such evidence. For example, this is a glass, I drank a glass of water and put it here. I have waived my right to basically use this DNA evidence for court purposes. But this cannot happen in India. If I've had water and kept it here and I've gone from here, the police can actually take up the DNA evidences left from the glass. So this is not the case in India. Now, when we talk about whether the court's order directing a blood sample for DNA profiling can physically be forced, if there is a case of rape or if there is a case of serious crimes, can they be physically pushed to give a test? Now, our constitution states that an accused cannot be self-incriminated. No person can be a witness against himself. But there have been cases that where physical enforcement of the accused has been done. If so, then what extent can they go to? Any such compulsion of any particular physical act, and not just merely a state of mind of any person who is giving a statement, except in a case where the mind has been so conditioned by something that is extraneous to that nature, which will result in making the statement as involuntary. It is making your statement involuntary because it is not in your hand. And when you are giving up a DNA testing, it is you are giving up, waiving your right of your mind, where you did not give consent to it, but there is an involuntary consent. Now, there are things, many compulsory testing or involuntary testing that has happened for drawing samples has been permitted. But
Ma'am, please conclude your topic.
Okay, so this was basically that they have allowed, however, only in criminal and serious cases. And it's not like use of force is uncommon in Indian judicial system. Force is used by police for execution of orders or decrees as a result of resistance. And therefore, when the police can be used to remove a person from illegally staying a property, the same can be done as a DNA collection test. So this is what a part of my study talks about.
Thank you, ma'am.
Thank you. Thank you.
I request Umang Banodia. I request Umang Banodia to present his paper. Akshat,
Yes, sir,
please.
he is joining.
Yes. Umang Banodia.
Okay. Am I audible and visible now?
Yes, you are audible and visible clearly.
Okay. Fine. Okay. Good afternoon, everyone. First of all, I thank Dr. Ramana Lohia, National Law University, Lucknow, the chairperson, Dr. Visalakshi ma'am, head of department, Dr. RML Analu, and co-chair, Dr. Kailash Zangar, sir, associate professor, National Law University, Assam, and the seminar committee for giving me a wonderful opportunity to express my thoughts on the topic, emerging issues in law and justice in the perspective of globalization. Myself, Banodia, and I am a research scholar at Dr. Ramana Lohia National Law University, Lucknow. And my topic of presentation is International Instruments and Constitutional Law on Torture, Issues and Challenges. I would like to begin with the data released by National Human Rights Commission that in the year 2019, 1,731 custodial deaths have been reported, which means on an average, 5 people die in custody daily. And I think this is a figure. Human Rights Watch has submitted its report, Bound by Brotherhood, India's failure to end killings in police custody, where they studied various custodial deaths between 2009 to 2015 and interrogated victims' family, witnesses, police officers, and other experts. And they concluded that the third-degree methods were used over all victims. And the biggest issue is that cases are not being registered in the case of custodial torture and deaths. And since most of the people who face custodial violence belong to uneducated, socially backward, or minorities class, and they are not aware of the rights provided to them under Constitution or Criminal Procedure Code or other statutes as well. And if you take examples from few of the movies of Bollywood, like Dabang, Singham, Rowdy Rathore, Satyamev Jayate, What do you find common in all those series and movies? The common thing is that you will witness police torture. And what we as a viewers do, we as a viewers generally encourage or promote the activities which are shown in the movies. And if you talk about the case of DK Basu, in this case, Supreme Court has stated that, and I quote, experiences show that the worst violation of the human rights take place during the course of investigation, where the police, with a view to secure evidence or confession, often use third-degree methods, including torture. And unfortunately, the guidelines of DK Basu judgment have never been followed completely by police in most of the cases. Here, I would like to quote few law commission's reports and committees on police reform, especially 113th Law Commission report, 273rd Law Commission report, and recently 2017 Law Commission report. And if we talk about 113th Law Commission report, it has recommended that there should be an amendment. It should be made in the Evidence Act that, importantly, I'm quoting it, if any death is caused in police custody, and in all that situation, it should be presumed that the police officer who arrested the victim has caused the death of that deceased. And 273rd Law Commission report has drafted Protection of Torture Bill. Unfortunately, it has been never passed by the Parliament. And recently in the year 2017, Law Commission said that we are seriously considering the bill. However, various changes are to be made in IPC or Evidence Act or CRPC so as to implement those bills. Okay, fine. And especially if we talk about the Padma Nabhaiya Committee report on police reform. And it has submitted its reports that today most people accept it to be the duty of the police. Today, most people accept it to be the duty of the police to coerce or to apply third-degree torture on the accused, so as to extract confession from them. Although I know, and you also being a student of law, all of you know that the confession given to the police by all those means are not acceptable in law, but still. And I would like to quote the statement given by Justice Deepak Gupta, retired Supreme Court Justice. And he said that we first need to implement the law as we have it. And he has said that the investigations, the prosecutions are not fair. These must be rectified first. And he exhorted that the police need to be trained better. And the temptation to use third-degree methods must be replaced with scientific skills. Therefore, the need of the hour is to strike at the root cause of the problem and implement the recommendations of various commissions to be bring in necessary reform. And here I would like to quote few of the landmark judgments of the Supreme Court regarding custodial violence and torture. And I hope each one of you have gone through all those case laws, such as Rudal Shah Saheli versus Commissioner of Police, Neelavati Bahera, Joginder Singh, and especially DK Basu. And in case of Rudal Shah, this was the first case when it was realized by the Supreme Court that if someone's human right or fundamental right has been taken away by the state, in that situation, he should be granted compensation. In Saheli versus Commissioner of Police, and this is an important case because in this case, Supreme Court gave opinion to the Delhi administration to recover the amount by the police officer who is responsible for the incident. And you know the facts of the case of Neelavati Bahera. And if you talk about the case of Joginder Singh versus state of Uttar Pradesh, and it said that if any arrest is done without any justification, then it will be an illegal arrest. There must be a reasonable justification for arresting someone. And the most important case on this point regarding custodial violence, you know, DK Basu versus state of West Bengal. And here the Supreme Court has recognized custodial violence and police torture and said that the custodial violence is an attack on human dignity, and it has released 11 guidelines, which are to be followed by the police officers while arresting someone. Fine. And India has signed International Convention for Civil and Political Rights. And also it is a signatory member to the Convention Against Torture, CAT. and other inhuman and degrading treatment. Fine. Although India has not ratified it yet, you have Article 253 with you in your constitution, which provides for the power of the parliament to legislate for giving effect to treaties and international agreement. You might have gone through Article 253, that if the government of India makes any treaty or concludes any treaty.
Umang, please conclude yourself.
Just 1 or 2 minutes, I'm about to finish. Article 21 of the Constitution protects right to life and personal liberty, wherever the right to life, as you know, all those things. But there is difference of opinion on this point. The general mentality is that truth cannot be revealed from an accused without torture. This is general mentality. And several people, including me, opine that those people whose duty is to maintain law and order, and if they start using torture, then it is not acceptable at all. The legal reform must be done in the direction to uphold the rule of law. Just 1 minute. And today, it is the dire need to do some fundamental changes in law so that people should feel safe with police personnel. Today, what you see, people are afraid of them. See, policing is a state subject, and we have adopted the concept of welfare state today, which is totally against the pre-independence era of colonial regime. So I recommend that protection of torture bill should be implemented and the guidelines of the D.K. Basu judgments to be strictly followed. And if any death is caused in police custody, and in that situation, it should be presumed that the police officer who arrested the victim has caused the death of the deceased. Fine. And lastly, I would like to recommend that so as to implement the recommendations of various commissions, so as to bring in necessary reform. That's all from my side. Thank you all. Bye.
I request Mukta Verma to come and present his paper. She is an academician and she is a professor also. I request Mukta Verma, ma'am, to come and present her paper.
So ma'am is here.
Am I audible?
Yes, ma'am, you are audible.
Okay, I have to present paper. So can I present paper to the PPT?
Yes, ma'am, PPT is allowed. You can.
Okay. And the camera is allowed?
Yes, ma'am, camera is allowed. You can open your camera.
Okay, okay. Okay, I am just sharing the screen. The screen is visible?
Yes, ma'am.
Okay. Okay, so the topic for the paper presentation is cyber crimes and laws in India, issues and challenges. The research questions are: what are the cyber crimes, and what are the factors responsible for the cyber crimes, and how many types of cyber crimes are there? What are the issues and challenges of responsible for the cyber crimes, and what are the different laws to prevent cyber crimes in India? And what are the different techniques through which the cyber crimes can be prevented? And before going to discuss this topic, the research hypothesis is implementation of law is not sufficient. We know laws is there, but their implementation is not working in proper way. And loss of data is prevalent in cyberspace, and it is important to prevent loss of data in online transactions. So when we are going to focus the cyber crime, then the meaning will be, we know that the cyber crimes word is contain two words. First is cyber and second is crime. So the cyber denote to the cyberspace in which the online transactions takes place with the help of the computer system, and the information will be in the form of digit. And when we goes to the crime, we all know the criminals know, and the crimes have been defined into different words, but when we go to the criminal act, the act which is forbidden by law, or the act which should be do in the proper way, then these terms can become under the crimes. So when we go to the cyber crimes mean all the crimes which commit in the cyberspace are known as the cyber crimes. But then we can see that what are the motives of the cyber crimes. Cyber crime have so many reasons, because we all know that we all are using the information technology devices and the use of information technology in our daily life. So with the help of this data, the cyber crimes can be committed. And under criminal law, the cyber crimes may be defined as the crimes which are done with the help of computer system and the internet to manipulate or destroy the data of the victim. Then the cyber crimes can be defined in another word. For example, when the computer or computer system or network is a target to commit the cyber crime, or in another way, the computer or computer system may be used as a tool to commit the cyber crime. So the cyber crime can be committed with the help of computer system in one condition, when the computer system can be used as a target, and in another situation the data can be used to commit the cyber crime. So if we see the first type of cyber crimes, the examples may be like trademark infringement, copyright infringement, destruction of data of computer, or the sending of Trojan horse, etc. And when the computer system is used as a tool to commit the cyber crimes, then it maybe come under the debit card or the credit card fraud. Then we can see there are again another classification for defining the cyber crimes. Like cyber crimes can be against the person, cyber crime can be against the money, or cyber crimes can be against the government. So if we see the cyber crimes against the person, the examples may be hate speech, violation of privacy, pornography, child pornography, maybe the examples in which the cyber crimes can be against the person. When we goes to the cyber crimes against the money, the examples may be credit card fraud, money laundering, and the theft of banks' personal information of any other person. And when we discuss the types of cyber crimes against the public or the government, the examples may be in the form of cyber terrorism or denial of services of the government utility services. Then further, another classification may be there like hacking, cyber stalking, and the theft of the intellectual property rights. Now we can see that what are the various tools through which the cyber crimes can be committed. Examples are viruses, Trojan horse, spam, phishing, spyware, malware, adware, and cookies are there, through which the data can be theft by the cyber criminals. Then the important point here is that what is the role of law? We all know that the IT Act was enacted in 2000. After that, the 2008 was a milestone in the field of information technology law. And if we focus on the important provision of IT Act, the main function of the IT Act is to recognize the online transaction, because we all know that before the 2000, if any online transaction is going on, then it don't have any authentication. So after the enactment of IT Act, the online transaction has a validity, it has the authenticity, and if any work has been done in cyberspace, that will have a value. For example, if any evidence is there that is available in cyberspace, then it can be used as electronic evidence if it is used in the court. So these are these certain provisions which are defined in the IT Act. For example, it allows the authentication of the electronic records by the digital signature, and the IT Act is also use the to sort out the various issues for the cyber crimes. For example, there is a provision of the establishment of the cyber appellate tribunal, and certain offenses and penalties are described. And it also defines the certain liabilities on the intermediaries. Then these are the important sections of the IT Act, under which the certain type of crimes have been defined. For example, if we see the section 43, it defines the penalty for damage to computer source, and the computer system. Section 65 deals with the tampering with computer source code, and section 66 deals with the hacking with computer system. Section 66B is dealing with the receiving a stolen computer resource, and section 66C define the identity theft, and section 66D define the cheating by the personation. And the very important section for the protection of privacy is section 66. It defines the violation of privacy, and section 66F deal with the cyber terrorism, and section 67 deals with the publishing of obscene information. Section 67A deals with the publishing material containing sexual explicit content. Section 67B deals with the child pornography. And the important provision that gave authority to the central government for the protection of data is section 69, section 69A, in which the central government has a power to intercept, monitor the data. And blocking of objectionable website in India can be there in the under the section 69A. And if we see the section 79, it imposes a liability on the intermediaries. For example, if cyber crimes have been committed in the form of violation of intellectual property rights, or if any one person data has been leaked, then the person who are intermediaries, or the intermediaries, for example, who are providing the internet services, they will be liable. And section 84B discuss about the abetment to commit an offense. Now, the last point is how these cyber crime can be prevented, because if we are aware that these are the cyber crimes, these are the different techniques, and these are the provisions of the IT Act, then some measures should be there so that the cyber crime cannot be committed. First point is here, implementation of law should be there, and the netizen should aware about the protection of their data, and they should use the privacy setting. They should not use the app which are not authenticated, and they should not we can say they should not give their data to the unknown who are strangers. And password of software and the computer system should be changes frequently, because we all know and we all aware that the password can be changed, or we can say the password can be traced, or password can be recovered by the any cyber criminals, but it takes time. So that it is said that the password should be changed frequently. And the important thing is there, people, family members and the parents should check the internet surfing and behavior of their children and teenagers, so that they can prevent from the harassment, cyber stalking, and the another types of cyber crimes. And people should report the police if there is a cyber crime have been committed. Conclusion is here, to prevent the cyber crime is privacy of data is utmost required, and all the type of cyber crimes can be done through the help of data or on the data. So the most important thing here is to protect the computer system. If computer system will be secure and the data will be protected, then up to some extent cybercrime can be prevented. Thank you, sir.
Thank you, ma'am, for presenting the topic. Now I invite Ms. Ishani Singh and Chandni Agarwal to present their paper. Ms. Ishani Singh and Chandni Agarwal. The question and answer session will be at the last, when each and every presenter will present the paper. So if you want to ask any question, you can write it on the chat box. If you want to ask any of the question to the presenter who has presented their paper. I invite Ms. Ishani Singh and Chandni Agarwal to present their paper.
Ishani ma'am is here. Chandni ma'am is just joining. Chandni ma'am is also here.
Chandni, please turn on your camera. Good afternoon, everyone. This is Ishani Singh. I am a practicing lawyer in Delhi, and I'm a founder partner, Lexington Partners, a niche law firm in Delhi. And I'm joined by my co-author, Chandni Agarwal. She's a senior partner in our firm only. I'm sharing a PowerPoint PPT that will go along with the paper presentation. Chairpersons, am I audible?
Yes, you are audible and you are visible, and your PPT is also visible to us.
Right. Good afternoon, everyone. Globalization changed the landscape of the Indian economy forever, of course. The implications were widespread and diverse that became apparent as the time passed. This paper aims at highlighting that more than the economy, it was the people of the nation whose rights were impacted by the new economic policy. It has further discussed that how in desperate attempt of salvaging our economy, the government was blindsided and did not take into account the legal, political, social and economic challenges that came along with it. Further, how important it is to encourage balance of rights of the business entities and basic human rights. Further, talking about how our papers is a little different from other papers is this paper has taken a rather relaxed approach towards globalization. We admit that globalization has not proved to be injurious in its entirety because, of course, it has resulted in economic upliftment and of several, and the exposure has led to technological advancement, widespread intellectual interactions, and smooth trade and commerce between nations. However, we strongly advocate the principle laid down by our constitution. India, being a welfare state, we are of the opinion that the state should not blindly run towards development without being considerate about those who are not privileged and belong to the marginalized communities. Talking about legal implications that were seen during or after globalization, we'll first cover RTI and globalization. Freedom of information facilitates good governance and encourages transparency. At present, over 75 nations have laws that give access to citizens to data and information held by national, state, and local governments for the flow of requisite information from authorities to citizens. This dates back down to 1755. The formulation of Right of Information Act 2005 can be said as a constructive outcome of globalization. Moving on, right to education and globalization. India has always been rich with human resources, and in order to improve the value of this particular resource, education plays an important role. All the nations that derived benefit out of globalization invested significantly in education and training processes. Globalization has broadened the horizon for higher education for us, of course, but the question of accessibility of quality primary education still looms upon us. Moving on, right to health and access to clean water and clean environment. Healthcare industry also witnessed a new age after globalization when there was growth of private sector in healthcare. With the increased investment by the private sectors in health sector, there has been a decline in the commitment of government and public health sector. The outbreak of novel coronavirus leading to a pandemic is the most apt example to explain how spread of fatal communicable diseases is unavoidable in this age and time. Further, there is no denying the fact that globalization has led to economic prosperity and opened up vast channels for development. But the impact of globalization on the environment is a prominent one and cannot be ignored. Now I invite Chandni Agarwal to continue, please.
Now let's talk about rights of laborers, workforce, and globalization. The implementation of new economic policy in 1991 meant more opportunities for workforce in India. However, the entire process of globalization posed various risks to the disadvantaged and vulnerable section of the society. It is further important to note that there are statutes and constitutional safeguards, but still a considerable section of the manpower is not protected, especially unorganized, women, migrants, agricultural laborers, etc. Moving on to tribal rights and sustainable development. One major problem that was faced by developing nations post-globalization was preserving their distinct culture. While and collaborating with various cultures. It is notable that losing authenticity of their cultures and traditions in the light of globalization is just one among many major problems that the tribal communities faced. In the last few decades, India has witnessed various agitations and litigations wherein these tribal communities and the state have been at loggerheads. Talking about human trafficking, human trafficking may be understood as rooted in poverty and in the background of inequality between developing and developed sovereign states, as the latter treats the former as a source for cheap labor and for a channel for sex commodities. India is known for cheap labor all over the world. India becomes the easiest target to supply cheap laborers in an illicit manner to other nations because of looming poverty and deprivation. The easiest targets that are inducted in human trafficking are women and children. So now let's discuss National Human Rights Commission. The National Human Rights Commission was constituted with the view to address human rights issue more effectively for the benefit of the citizen of country. However, the efforts made by the NHRC in this direction shall lose meaning if the state and non-state actors do not work in tandem with NHRC in order to strengthen the human rights situation in the nation. So concluding the paper, we would like to say that if globalization has helped a few, it has also made many helpless too. It is high time that we understand that there are certain rights like education, healthcare, clean environment, etc., that should be available to everyone despite their economic status. And we have failed to do so even after 75 years of independence and 30 years of globalization. It is immensely important that state as well as non-state actors, including the corporates, work hand in hand to improve the appalling pictures of the nation. Further, it is likely that in the future, these issues shall be voiced out more strongly to battle the unfavorable aspect of globalization. Thank you.
Thank you.
I invite Ms. Kalandri, Assistant Professor, to present his paper. Ms. Kalandri, Assistant Professor.
Yes, sir, she has
I invite you to present her paper.
Kalandri ma'am, please unmute your mic.
Good afternoon, everyone.
Good afternoon, ma'am.
So myself, Dr. Kalandri, Assistant Professor, Lucknow University, and my topic is violence against women during pandemic. So violence against women, it is an existing global crisis that thrives on other crises. Conflict, climate-related disasters, food insecurity, and human rights violations all contributes to the women and girls living with a sense of danger, even in their own homes, neighborhoods, or communities. With 1 in 3 women worldwide, they have experienced physical or sexual violence inflicted by an intimate partner or non-partner at some point in their lifetime. But this COVID-19 pandemic has worsened the situation, which necessitated isolation and social distancing, enabled a second shadow pandemic of violence against women and girls, where they often found themselves in lockdown with their abusers. The crisis has generated additional barriers for women and girls' access to essential life services like counseling and legal advice, help of police and other justice sources, and sexual health-related issues and other crucial medical assistance. Women who face greater vulnerability to multiple forms of discrimination included older women, those living with disabilities, LGBTs, trans women, migrants, displaced and refugee women, victims of armed conflict, rural women, and those who are living in the informal settlements. if we take one example, I would like to quote that a victim of regular verbal and emotional domestic violence claimed that she had her job as a savior from her husband brutality. Her husband's job also kept her away from her. With this imposition of the lockdown, she had to live in a constant state of fear of victimization. So if we talk about the number of complaints in different parts of the world, it has increased. For example, in Argentina, the number of daily calls which they received was up to 39%. In Mexico, it increased by 53%. And if we talk about India, in Tamil Nadu itself, at least 25 complaints were received daily. So this was happening in different parts of the country, including India also. So if we talk about the different causes or various factors which are responsible for this, it is not the virus itself, but rather an imbalance of power and control, which stems from inequality between men and women, discriminatory attitudes and beliefs, gender stereotypes, social norms that tolerate and perpetuate violence and abuse, and societal structures that replicate inequality and discrimination. Now, there is if we talk about the impact, what is the impact of such kind of violence on the victim? Such type of violence, it leads to homicide or suicidal attempts. It leads to depression, eating disorders, and post-traumatic stress, headaches, gastrointestinal disorders, and the sexual violence, particularly during childhood, can lead to increased smoking, substance use, and risky sexual behaviors. Women during pandemic, they also suffered isolation, inability to work, loss of wages was also there. And this type of violence related to women, it leads to lack of participation in the regular activities and limits the ability to care for themselves and their children. So I would like to give some suggestions also, that there is a need for a psychological intervention. Psychological support is required for survivors of intimate partner violence. And there is a need to organize economic and social empowerment programs. There is a need to work also with those couples who are facing such problems to improve communication and relationship skills. Community mobilization intervention is also required so as to change unequal gender norms. There is also a very necessary step which is required to be taken, that is to organize different awareness programs at the school and college levels, and it should be included in the curriculum that challenges gender stereotypes and promote relationships based on equality and consent. And if we talk about the different sectors like police, judiciary, media, NGOs, and we as the society members, we are also responsible citizens, and we should behave like that, and we should cooperate in such type of cases. So there is a need for organizing the gender awareness programs, because training is also needed so that the police, the different sections of the society, they can perform efficiently. So this type of problem against women, that is the violence against women, it should be treated as a public health problem. And at the last, I would like to say that to achieve a solution to it, it is important to enact and enforce the legislation and develop and implement policies that promote gender equality. Thank you.
I invite Manoj Kumar Chaudhary, research scholar, to present his or her paper. Manoj Kumar Chaudhary, to present his paper. Thank you, Kalindi ma'am. Manoj Kumar Chaudhary. I invite Manoj Kumar Chaudhary.
Yes, sir. Manoj sir has joined. I will request Manoj sir to unmute.
Manoj sir, please present your paper. Akshat, the presenter is there. Mr. Manoj.
Yes, sir, the presenter is there, but I don't know what is happening. He's not responding.
So should I invite other presenter?
Yes, sir. I will call Mr. Sandeep.
Okay, okay. I invite Mr. Sandeep Mishra to present his paper in this technical session. Mr. Sandeep Mishra. Mr. Sandeep Mishra.
Yes, sir. He is joining in a minute.
Okay. Akshat, is there any problem?
Yes, sir. Sandeep sir is joining.
There is network issue.
Yes, sir. There was some network issue.
Okay.
Good afternoon, sir.
Good afternoon, Mr. Sandeep. You can present your paper.
Yes, sir. Thank you, sir. With your permission, I'd like to start my presentation. My topic for the session is based on a current event that happened on cyberspace, is the incident of Bully Bhai app. Recently, in social media, an incident of women trading was reported, named Bully Bhai of the day. Several social media platforms has some posts that contain of photos of a particular group of women. They are socially active and very vocal on some media platforms. A network, a open source software called GitHub, as the source of the application. That application was called as Bully Bhai app. Bully Bhai app of the day, an online platform driven by GitHub.
Akshat, is there any problem? I think I'm not able to listen his voice.
Yes, sir. There is some network problem.
Okay.
So Mr. Sandeep is facing some network issue. I think we should give him a minute so that he could.
So we can. Is there Manoj Kumar Chaudhary is there?
So we are trying to contact him, but he's not responding to any of the text.
Okay. So the last presenter can we call for the day?
The last presenter of the day is Mr. Sandeep only.
Doctor. Okay, the last presenter is Mr. Sandeep Mishra.
Yes, sir.
Okay.
So I think we should give him a minute so that he could check it out.
Yes,
what his
yes,
presentation.
yes. You can take the time for Sandeep. And if you see that Manoj Kumar Chaudhary is there, then to him also. You
Okay,
can
sir.
contact him.
Yes, Sandeep sir, you can continue.
Sandeep ji, you are not audible. Please unmute yourself.
Sorry, sir, for disturbance. I think
Yes,
there
yes.
is congestion.
Yes, you can continue
Sir,
yourself.
Yes, sir. When like we are talking about the constitutional perspective of discrimination, as we know, Indian Constitution guarantees equality to every person without any discrimination on the basis of religion, race, language, caste, or creed. Women is a vulnerable class as per the right guaranteed by Constitution, and there are several laws who are implemented to take course to save the rights of women. Cyberspace is a developing platform in virtual world to explore, to profess, to share their ideas. And open source software is a platform where every person who is skilled in programming, who is skilled in technical advancement, can share their ideas, make applications, create bugs, and fill the gap. This is open for all. And with the use of coding, they can create platforms, create applications for the use of netizens. In this current event, earlier 6 months before, also same incident has taken place called Sulli deals. After the Sulli deals, it also contains same application on same GitHub platforms. It has the very same features of the offense, and there are more photograph of women of particular caste with lewd comments flows on social media platform. This type of act of offenders destroy the social fabric of country. In the contemporary times, use of internet is increasing day by day. Our everyday life is surrounded by internet. We take of internet to demand of our everyday uses like banking, internet to sell or purchase our used goods and grocery items through internet. The use of internet varies from user to user, and individual may use it for work, some for businesses, some for entertainment, but some use the internet to creating rush and disturbance in the society. Online platforms
Akshat, I think there is a technical glitch.
Yes, sir.
But they use
Yes, you can continue, Sandeep ji.
okay, thank you, sir. But they use the app for wrong purposes. The mock photograph of women were floating on social media sites like Twitter and WhatsApp. Photos of that women's were taken from their social media profiles, their videos, their photos from their posts. In this case, an FIR was registered in several stations of India, and 4 people were arrested from the different locations of India. Coincidentally, they are all were youngsters, and they have very good academic records. Some were engineers, and I remembered a case named Chat Group Case, Voice Locker app, where some students were talking about their friend in very lewd comments. They talk in very indecent manners about their physique, about their body language on a voice locker room. That incident was happened in Delhi. Several students was arrested in this case. Same case was again repeated, and now it is a very large form of the case called Sulli deals. After Sulli deals, same incident was happened, bully deals of the day. Now I like to conclude my topic. I want to submit that the modesty of women is very important, and it is protected from several acts like Indian Penal Code and the Misrepresentation of Women's Act. And also there was an act called Information and Technology Act 2000, which deals with the cyber offenses.
Please conclude yourself.
Sir, yes, sir. I like to conclude that these type of crimes to outraging, which has been done through the use of social media site, should be restricted and need a stricter legislation to deal with the offenders. Thank you, sir.
Thank you, Sandeep ji. Now I request the chairperson, Dr. V. Vishalakshi ma'am.
Excuse me, sir.
Yes.
Sorry to interrupt you, but Manoj sir is here now.
Okay. Ask Manoj Chaudhary.
May I leave now, sir?
Yes, you can leave.
Thank you, sir.
Akshat, ask Manoj ji to continue.
Yes, sir. Just a minute.
Mr. Manoj, please unmute yourself. We have not muted you. Mr. Manoj? Please unmute yourself. There is no foundation from our side. You can unmute yourself.
Sir, he's facing some issue. It will be resolved in few minutes. Sorry for the inconvenience, sir.
Hello? Hello?
Yes, sir, you are audible.
Yes.
Okay, sir, this time, so why this, I can't understand why this is happening, technical problem. Hello? Am I audible? Hello?
Yes, sir, you are audible.
So may I present my paper?
Yes, sir.
Okay. Just give me a moment. I'm sharing my PPT. One minute. This time there's a problem of sharing the PPT, I think, document. Sorry, I'm unable to share it. Can I send it to someone so that he can present the PPT, please? Hello? Hello?
Sir, sharing the
Yes.
presentation is allowed. Everyone else is shared, sir.
There are so many things, Google Drive, Box, photos, document, but there's no, there's some problem, I think. I'm not able to get it. Hello, can I share it in the group, please?
Yes, you can share it.
Okay, sorry for the interruption, sorry.
Sir, there is no problem from our side. You can present your paper without a PPT.
Okay, I have presented in, send it in the group, please. Can you present it on the screen, please? I'm not getting it out because I have presented it several times with the Google Meet and Microsoft Meet, not getting how to present it with the Zoom. So good afternoon, everybody. I'm Manoj Kumar Chaudhary, doctoral fellow from Mahatma Gandhi Central University. And my paper is on human rights of migrant workers, challenges of the new decade. So basically, what are the migrant workers, human rights violations, because they are not receiving the citizens of states due to their status often live in precarious situation. Women migrants have to deal with additional challenges as they have faced human rights violations based on their migrant status, as well as based on their sex, caste, creed, race, etc. So migration is as a phenomena has always existed, while the absolute number of migrants has risen in the past decades to reach some 200 million. They continue to make up around 3% of the world population. Notwithstanding, migration has become strictly linked to globalization and its effects for foreign-born workers. 10% or more of forces in many Western European countries, 15% in North America, and even higher proportions in Africa and Middle East. Indeed, migration became a key features of meeting economic labor market and productivity challenges in the globalized economy. It serves as a instrument to adjust the skills, age, and sectoral composition of national, regional labor markets. However, due to economic, demographic, and technological changes, migration is central to the future economic survival of the North as well as the South. Migration poses a number of challenges. It is often the result of lack of decent work, human rights violations, and poverty in countries of origin. Migrant workers still largely perform dirty, dangerous, and degrading jobs to sustain sectors of economic activity. They are no longer attractive for local work populations. These include agriculture and food processing, construction in real estate sectors, cleaning, as well as in maintenance of hotel, restaurant, backroom services, labor-intensive assembly and manufacturing, the sex industry, and domestic labor. In addition, there is a higher need for highly educated and skilled labor, which has led to a significant brain drain in countries of origin. It is becoming increasingly apparent that migration can and should be a mutually beneficial situation for both sending and receiving countries, and most importantly for migrants and their families. In 1981, the Nobel Prize winner James Tobin was asked to explain the benefits of diversification in this simple language. He stated, "Don't pull your eggs in one basket." Institutional investors cite diversification as one of the main reasons for globalization and their real estate portfolios. Now, what are the legal framework for the migrant workers and the human rights that are being violated from the bureaucratic as well as the political culture? The first law relating to immigration was the Indian Immigration Act 1922. This was replaced by the Immigration Act 1983 because the parameters of India's migration policy had changed and there was an urgent need to draft an appropriate legislation to meet the growing requirement of the migrant workers in the Gulf countries. The Immigration Act 1983 reflected more or less the ethos of an independent India that was concerned with the welfare of its migrant population. The primary focus shifted from control to protection of these who could not protect themselves. It was therefore befitting that the topmost official order 1922 Act, the Controller General of Immigrants, designed the Protector General of Immigrants in 1983. The Ministry of External Affairs, however, continues to be involved in the matter of the immigration at the initial stages, since the issue of travel documents is still under its jurisdiction. Indian diplomatic missions which functions under the control of this ministry are involved in the migration process at different stages. Now, what are the employment perspective of human rights as well as migrant labor right? Interstate Workmen Act 1983 Act is limited relevance in collecting data on migrant workers, as a large category of persons fall outside its ambit. At present, persons falling under 17 categories are exempted from obtaining immigration clearance. There is also no need for clearance for going to be United States and the Western countries. The data, therefore, is available only in respect of person migrating to Gulf countries, and within that, only for those fall in the category of unskilled, semi-skilled, or skilled workers. On yearly basis, immigration clearance for the last 15 years have varied from 4,38,000 in 1993 and 1,99,552 workers in 1999 and 22,93,800 in 2021. The decline in the number of immigrating persons in 1919 is primarily due to the determined efforts of the government. On household economy of migrant workers and the family life varies from a large part of the remittances are used for the household consumption, which is 86% of the households maintaining living expenses as the main item of expenditure. If we talk about the children's education, migrations has led to the increasing number of children availing of education. Immigrants have helped in upgrading and educational institution in their villages, making schools more accessible. Besides, parents can now afford to send their children to better school beyond their own villages. What are the social cost of this? On the flip side, migration has its social cost as well. The migration of male workers in the family gives rise to feelings of loneliness. If we talk about the Vrindavan Yojana in Lucknow, Uttar Pradesh, we have visited 7 sites: Ansal, NCC, Gangotri, Yamunotri, Rajvans, and we have found that many women harassment issues has been seen and they have been violated from time to time from the contractor in the name of workforce. Human and Rebel Rights, according to the report of High Level Committee on Indian Diaspora submitted in December 2001, the Indian migrants constituted 10 million strong communities spread across the world, and its role has been well recognized by the receiving countries. It would be useful to look at the issues of the rights of migrants from two perspectives, that of illegal migration and legal migration. Illegal migration is a multi-million-dollar industry with the craze to go abroad and earn in dollars, resulting in people being lured by agents, many of whom are night by night operators.
Manojji, please conclude yourself.
Okay, sir.
Manojji, please conclude yourself.
Okay, sure, sir. I'm on conclusion.
Okay.
So basically, migrant workers, and if you talk about the migration workers and discrimination under ILO Convention number 111, in some countries, a person belonging to racial and ethnic majorities mainly consist of foreign workers, immigrants of the descendants of immigrants, while Article 1 of the convention does not refer specifically to racially, both grounds covered by the convention. There has been several issues arising from time to time in European countries as well as in developing countries, and we have to also look at the factors of civil society, that we have to prepare data and NGOs involved in migrant workers issues on countryside basis, encourage the setting up of NRIs, migrants bodies in the sending countries, which we can look, and these are the measures we have to adopt as well. Consider socially indulging in human trafficking and displacing their name at important public places, considering innovative ways in which the media should be involved, and ratio would be an important channel to promote such awareness. And recommendation should be given, and the following out of the above scenario would broadly focus on awareness, informants of law, involvement of trade unions and civil society. But would be important in these cases to take stock of the stages of implementation of various international activities, seminars and conferences on migration, with a view to determining those proposals which have been implemented or feasible to implement it, and then we have to popularize them for implementation by different bodies, government, employers, trade unions, civil society, ILO, etc. And the specific recommendation with respect to the various categories should be followed and enacted well. And last but not the least, that migrant workers are the first and the last need of our basic human amenities. Thank you from my side. Thank you, panelists.
Thank you, Manoj ji.
Okay, thank you, sir.
Thank you. Akshat.
Yes, sir.
All
the participants have been over.
Okay.
So should I give entry to all the participants so you can give the vote of thanks?
No, I will be inviting the chairperson to share her views.
Yeah.
I invite Chairperson Dr. V. Vishalakshi ma'am to share her views on the theme which has been discussed in this technical session. Dr. Vishalakshi ma'am, Head of the Department of Legal Studies, Dr. Ramanolia National Law University. Ma'am, please share your views on this topic. Today's technical session was on human rights in global world and contemporary issues and challenges. I request Dr. V. Vishalakshi ma'am to present his views on this topic.
Yeah. Thank you, Vivek.
Thank you, ma'am. Yes, ma'am. Please share your views, ma'am.
All presenters have presented the relevant contemporary issues relating to human rights in global world. When it comes to first presentation, he has covered freedom of speech, part 3rd of the Constitution. Second, Abhishek Dwivedi. So he has covered case 1 and the Bharati, again freedom of speech. And the number of cases he has referred. Ramanathan versus State of UP. So his opinion, great power imposes great responsibility. Third presenter, vis-a-vis private rights. In view of globalization, variety of crimes are coming up. These cases should be dealt with carefully by using technology. The presenter has covered DNA evidence and section 112 of the Evidence Act. So difference between India and the US as regards the manner of taking a DNA test. Next presenter, Umang Banodaya. He was talking about custodial deaths, police using 3rd-degree torture. So his opinion, custodial death is an attack on human dignity. It is the opinion of anybody. So the impression that truth cannot be ascertained without using torture, that should not be accepted. Torture bill should be implemented. He focused on D.K. Basu case. So far as this police tortures 3rd degree is concerned, recently it happened in Andhra Pradesh. Mr. Raghuram Krishna Raju, MP of YSR party, against whom police used 3rd degree torture. That was proved also. So these things are happening. So that is why serious. Even our Chief Justice of India also pointed out about the 3rd degree, vis-a-vis even politicians also. So these should be curtailed, prevented or prohibited. Already there, but implementation problem, everybody knows of it. Next, Mukta Verma, cyber crimes. So what are the cyber crimes? How many cyber crimes? Types of cyber crimes? She has covered, and IT Act 2000 she covered. So she suggested apps not authenticated should not be used. Passwords anyway should be changed frequently. Nowadays, these people are doing this. So police should be informed if any cyber crime is committed. She has suggested. Next, Ishani Singh, Chandini Agarwal. Globalization and human rights, they have covered rights of labor, tribal rights, sustainable development, human trafficking, right to health, access to clean and environment. So far as environment is concerned, everybody knows how many acts we are having. And I'm coming to the point, so many measures are taken or union government is taking. And the Clean Ganga project, etc. I'm coming to that point. Next presenter, Kalindri. Kalindri, her topic is violence against women during COVID-19. Her opinion, it must be fact. And violence against women during COVID-19 is increased in various parts of the globe. So it will have natural psychological support, means psychological effect. So that may lead to suicides. So psychological support is required to women. Gender awareness programs should be organized. So for protecting gender equality, government should enact laws. She has given these suggestions. So Manoj Kumar Chaudhary, his topic is human rights of migrant workers, challenges of the new decade. Anyway, human rights violation is happening against migrant workers by bureaucrats. So media also should be involved. Sandeep Mishra, his topic is Billy Boy app. So he focused on photos of women on social media platforms. So internet is creating disturbance to the society. These types of crimes should be prevented. Modesty of women is important, he pointed out. And all these topics are good, and the presenters have done their performance decently, clearly. On behalf of RML and you, I congratulate you. And when we organize any program, again and again you participate. It is a pleasure to have you people again. So far as central government measures are concerned, in the 2018 Union Government, India has published a National Action Plan. So in that plan, first part, government has mentioned areas and applicable laws and the measures taken by Indian government to respect and protect human rights. When it comes to business, yes, CSR, corporate social responsibility, was made mandatory under Section 135 of the Companies Act. When it comes to consumers, Consumer Protection Act was also passed. So environmental protection ke liye Swachh Bharat, everybody knows of it. Namami Gang, Clean Ganga project, also government has taken. When it comes to protect rights of workers, we know how many acts. Acts are there, implementation should be there. That is always there. Building and even construction workers welfare, Cess Act 1996 was passed. When it comes to women, sexual harassment of women at workplace, Prevention, Prohibition, Redressal Act 2013 was passed. And especially regarding women, Beti Bachao, Beti Padhao, save the girl child, educate the girl child. Also, our government has taken these measures. So regarding child labor, we know so many acts, Prohibition and Regulation Act, Child Labor Prohibition and Regulation Act 1986, Juvenile Justice Care and Protection Children Act 2000 were there. And for transparency and accountability, the Pradhan Mantri Jan Dhan Yojana is the largest financial inclusion program. So that is also that this step government has taken. Again, when it comes to transparency, public procurement, JAM portal, because there are some conditions up to above this amount, government department shall have to buy their requirements through JAM portal. And the JAM portal separate rules are passed. So if we follow this method, there will be transparency because registered bidders will participate. So in 2018, the Union government launched e-marketplace, that is portal. So yes, our government has been taking so many measures, even under the international instruments, accordingly to protect, to respect and to protect. In National Action Plan, if we see, no new acts were passed, but all existing acts and other measures taken by the Indian government are enumerated in part 1. Part 2, anyway, business human rights, morning I have covered, I don't want to repeat that. And the redressal mechanism, everybody knows, courts and even arbitration, conciliation, mediation, e-arbitration, and conciliation. Remedies are also there. And practically, being a member of UN, yes, the Indian government is always ready to adopt and implement. At the time of implementation, yes, we are facing problem. Just it is my opinion, the governments of these countries, because in view of globalization, if they want to curb or prohibit any crime or any violation of human rights, then if these governments formulate policies in consultation with other governments of various states, having regard to their national legal systems, because implementation ke liye separate mechanism is required. If mechanism is not there, that should be developed. So that is why keeping the local implementation mechanism, if the governments of various countries in consultation with each other or in some joint meeting, if policies are formulated and if they are implemented, then these human rights violation may be restrained globally. Similarly, human rights organizations, they should also, if they contact with similar organizations in other countries, because of this coordination and cooperation, they will also be able to solve or resolve certain issues globally. So like this, if something can be done, so violation of human rights, not only violation, to respect, to protect human rights, that can be done, that can be protected. So human rights, vast area, so many aspects, medical human rights, so many. So that is why to prevent this violation, governments of various countries, if they come together, there, according to me, there is a possibility at least to restrain the violation of human rights globally. Just these are some of my views. And thank you, co-chair. And if Mr. Kailash Jingal, and I request you to share your opinion.
Thank you, ma'am. Am I audible to all of you?
Yes, yes.
I request to the chairperson and the co-chairperson that one of our presenter was not able to present his paper because of the high technical glitch. So I request to the chairperson, the co-chairperson to give the allowance that the presenter can present his paper because he has joined. So if your allowance is there, so that he can present his paper. I request to the chair and the co-chairperson.
Dr. Manoj, your paper.
Yes,
ma'am. I have been waiting since 2 o'clock and I don't know what kind of technical glitch was there because I was supplied that routine and I was the last one to present my paper and announcement was made that now the presentations are over for today without taking my presentation. So I was.
May I request co-chair Dr. Kailash Jingal, let us permit Dr. Manoj, and he is our colleague and assistant professor. He is working in RML NLU. With your kind permission, Dr. Manoj can start presentation.
Of course, ma'am. Why not? I think we should allow him.
Please start presentation, Dr. Manoj.
Okay. Very thank you to our Honorable HOD Madam, V. Vishalakshmi Ma'am, my colleague Dr. Prem Kumar Gautam, and organizing team for giving me this opportunity to deliver my presentation on the topic Economic Regulation in India, Post-Liberalization Era. So when we talk about regulatory process, as all of us know that regulation, it is a process under which some of the area of human activity is regulated. And accordingly, different laws are passed by the state legislatures, by the parliament at central level. Different laws are passed. So economic regulation in India, it is a topic which relates to each and every person in the society. Because as we know that if we see the history of regulation and regulatory process, we can trace back the history to European countries when industrial revolution was taking place. And in the industrial revolution, theories of social help, theories of self-help, individualism, Darwin's theory of survival of the fittest, it was there. And as a result, the political philosophy of laissez-faire was there. State role was considered to be negative state and economy was left free. Economy was left free that every person is the best judge of his own interest. And accordingly, economic interests can be taken care at best by the individual himself. So the state was not intervening into the economic activities. We also call it as free market economy. That a free market economy was there, where no governmental control had to be there. So I'm just skipping because there has been paucity of time and I'm just discussing the position in India. In India, we can see the economic regulation at 3 phases. Before 1947, between 1947 to 1991, and 1991 onwards. Before 1947, we can say that a political philosophy of laissez-faire was there, where the state role was to be considered to be negative state. The role had to be a negative role, and the state had to contain itself only with the three core sovereign functions that you will have to defend against external aggression. You will have to collect taxes, administration of justice, few of the subjects, and collection of the taxes. So these were the three core functions for which government had to contain, and the government were not keeping any check, any control on economic activity. Economy was let free. As we know that Indian territories were occupied by the Britishers. Initially, it was the East India Company. Later on, after 1858 onwards, when the Gadar was there. So after that, Britishers, they occupied Indian territories, though the Indian legal system, as we inherit today, as we see today, that system was established by the Britishers. But this system, it was established by the Britishers in order to cater their own needs. Because they came in India in order to do business, and no business can be carried on smoothly unless there has been proper law and order conditions. So they established the Indian legal system because they were well conversant with their own legal system. And whatever laws they were found suitable to the Indian territories, to the Indian conditions, these laws they had been implemented, or similar laws had been passed for India. So in British Parliament, if these laws they had been passed, governors had to be appointed, legal system, courts were established, mayors courts, high courts, Supreme Court, these courts they had been established. So this was the role of the state. That state role was considered to be negative state. Now in 1947 we got independence, and after that Constitution of India was adopted by us. In the Constitution, the state role was changed from laissez-faire to social welfare state. So the earlier philosophy of laissez-faire, it was converted into the parens patriae. Parens patriae, that the state will have to behave like parents on behalf of all its citizens. So accordingly, this concept of parens patriae, it had to be there. The state role was changed from negative state to the positive state. So in this era, in 1947 to 1991, when the state role was declared as social welfare state, being a social welfare state, so state started undertaking various types of activities. Now the state was running buses, the state was providing railway services, state was undertaking insurance sector, public utility services, key industries, almost each and everything. It was done by the state. And as we know that in every healthy democracy, it has to be governed by rule of law. Accordingly, relevant laws had to be passed. Relevant laws were passed by the Indian Parliament. So certain land reform laws, they were passed. Laws were passed for betterment, for good conditions for workmen. Laws were passed for the betterment of the downtrodden sections of the society, poor persons of the societies, for SC, ST atrocities. Different laws were passed. Land sealing laws, land reform, they were passed. Subsidies were also started by the state. So in public utility services, government undertook running of buses, running of railways, providing insurance policies. That government, they went up to the extent that in these public utility services, key public utility services, that proper governmental check was there, a rigid regulated economy was created, complete governmental monopoly was created, and private players, they were not allowed to enter. So we can take example of insurance sector, that in life insurance sector, complete monopoly was created. In life insurance, similarly in general insurance also, so complete monopoly was created. So it was an era which we can say that a rigid regulated economy was there.
Dr. Banos, would you please conclude?
Yes, ma'am.
Yeah.
Ma'am, I have just started. I have been waiting since 3 o'clock, so give me at least 10 minutes so that I can deliver a good talk.
I think co-chair Dr. Kailash Jinger, so some program, other program, so that is way.
Okay. So I will tell in brief what is all about my presentation, and then I will conclude in 5 or 7 minutes. So what happened that government monopoly was created, and we saw the results that whenever government they had entered into a public utility services or for any industry, so there had been high corruptions, there had been poor services, and the conditions were bad. In 90s, when Harshad Mehta scam was there, Satyam scams were there. So due to these scams, the gates of the economy, they had to open for the private players. So the new economic policy of liberalization, globalization, and privatization, it was adopted in India. So after 1991 onwards, we can see that now the private players accept sovereign functions. They have been or they are allowed to enter into the FDI schemes has been launched. So these are the results. Now, what I wish to mention here, that after 1991 onwards, we are leading towards a free market economy. That the government is not keeping any check on the activities which are to be made by the businessmen, by the big houses, by the corporate houses. So at this moment, there had been a constitutional duty on the part of the state that the rights and liberties of the citizens, they should not be encroached upon. That the government will have to make a balance between the two competing interests, that on one side, development, infrastructural facilities, they are to be provided. On other side, it will have to also to be seen that the people's rights and liberties, as which are guaranteed under the Constitution of India, they should not be encroached upon. They should not be touched upon even by private players. So in this era, we can see that wherever the government departments, they try to maintain a fair competition, private players, they were allowed to enter into such fields. Regulatory authority, different regulatory authorities had been created. So initially it was the SEBI, Security Exchange Board of India. So by the Act of 1992, then IRDA, Competition Commission, Electricity Regulatory Commissions, the latest one, RERA, Real Estate Regulatory Authorities. And in 2019, the Act has been all repealed and it replaced by the 2019 Act, the Consumer Protection Act 2019. So under this Act, the Consumer Protection Regulatory Authority, it has been created. So the basic job of the regulatory authorities, that these regulatory authorities, they are performing three types of functions, that they are trying to maintain free and fair market economy. Secondly, they are trying to lay down the standards of health and safety. And thirdly, they are providing minimum and maximum tariffs for the goods and services. So in conclusion, I would like to say that every free market economy, it is having its own dangers. It is good that we are moving towards a free market economy. We are trying to achieve economic development in good GDP in India. So that is good, but we will have to also keep in mind that every government has to keep in mind that there has been constitutional mandate, and that constitutional mandate must be taken care. And what is the constitutional mandate? That the rights and liberties of the state, they are rights and liberties of the citizens, they are to be protected by the state. So state is duty bound to protect the rights and liberties of the citizens, particularly fundamental rights, and they need to follow the directive principles of state policy. So in this era of economic liberalization, globalization, we have seen that several sectoral specific regulatory authorities, they have been set up, they have been created, but there is need to strengthen the hands of these regulatory authorities. Much more improvements needed to be made in these regulatory authorities, because the scams in the corporate houses, they are not stopping, and it is the public money which is being cheated by these people, which is being taken away from India by these foreign players, private players, because even if they are Indian nationals, they are flying to foreign nations. As soon as they commit these kinds of cases of fraud, so they move. Vijay Mallya, Lalit Modi, all these cases are there. So there is need to strengthen the role, the capacity, and that they need to provide it the technical know-how and as well as other aspects, so that a good society can be maintained. That's all, ma'am. Thank you very much for giving me this opportunity.
It is our pleasure.
Thank you, ma'am. Thank you.
I request Dr. Kailash Jangar, sir, Associate Professor, NLU Assam, to give the concluding remarks on this technical session, whose theme is human rights in global world, contemporary issues and challenges. Please, sir, give the concluding remarks on this technical session.
Thank you, Mr. Vivek. I think the biggest handicap that the organization and the participants face in these seminars is actually the time limits.
Yes.
They don't allow much time to the participants, and therefore they cannot speak properly, or they cannot present their paper fully, actually, right? But given that constraint, I think all the participants have done well so far as the flagging of the issue is concerned, because I think in the time of 5 to 10 minutes, one can simply flag the issue instead of describe the arguments properly, actually, right? So I think all of them have done so far as the flagging of the issue is concerned. I would especially like to congratulate those who have talked upon some uncommon themes, like Manna talked about privacy and forensic examination reports, like Karandri talked about violence against women during pandemic, or like Manoj Kumar talked about human rights of migrant workers. And similarly, Sandeep Mishra talked about use of social media for hate propaganda. So overall, I would like to congratulate all the participants. They have done extremely well. Thank you so much for inviting me as well in this seminar. Thank you.
I hope this relationship will be continued in future.
Thank you, ma'am.
And Mr. Vivek, it is our privilege in having
Thank you, ma'am. Thank you, ma'am. Thank you, ma'am.
All participants, so please, and again, our seminar committee continuously has been organizing programs, and please try to participate in all the programs. Thank you, one and all.
Okay.
Over to Akshat. Thank you, ma'am. Thank you, sir.
Thank you, sir. So, would you would you like to go to the honors for giving vote of thanks?
Yes. So, in the end of this session, the panel, the technical session 2 has been ended, and I have been given the opportunity to give the vote of thanks. So, good evening, everyone. Respected Professor Dr. V. Vishalakshi, Madam, Head of the Department of Legal Studies, Dr. Ram Manohar Lohia, National Law University, and Dr. Kailash Jangar, Associate Professor, National Law University, Assam, are the well-invited guests, as well as the participant who has participated in this technical session. I give them a very warm full thanks to. On the behalf of the RMLNLU fraternity, I take this opportunity to propose the vote of thanks to those who have directly and indirectly contributed to the conduction of this panel discussion on human rights in global world, contemporary issues and challenges, which is organized by the Dr. Ram Manohar Lohia National Law University. At the very outset, I would like to extend our heartfelt gratitude to the dignitaries for accepting the invitation and addressing the gathering today. We are really enlightened with your knowledge, sir and ma'am, and your presence. We are thankful to the Vice Chancellor, Professor Dr. Subir Bhatnagar, sir, and the Head of the Department of Legal Studies, Dr. V. Vishalakshi, ma'am, and who was the chairperson of this technical session, as well as to Dr. Kailash Jangar, Associate Professor of NLU Assam, who was the co-chairperson, and the coordinator of this seminar, Dr. Prem Kumar Gautam, sir, Assistant Professor, Dr. Ram Manohar Lohia National Law University. I congratulate them. I say thanks to them for conduction of this program. I would also recognize and express our great regards to the non-teaching staff of the university for the support and upliftment, and which we have received from them. And a special thanks to the organizing committee and the students of the RMLNLU who have done a very good work to organize this seminar, and they need a huge round of applause also for the unflinching support and coordination. And we look forward to host more upcoming events in future. And in the last, I would like to say that the university will be organizing more seminars and more programs for the researchers, as well as for the new upcoming legal researchers and the teachers. So we want that you should come and participate. And with this warm words, and kind message, we move to the ends of the today's panel discussion. Thank you.
Thank
you to everyone.
Namaste to everybody. Thank you, one
Thank you,
and
everyone.
all.
Thank you all the participants and co-chairs and chairs. Thank you, everyone.
Thank you. We shall be thankful to you organizers and to organize this program. Thank you, one and all.
Thank you, ma'am. Thank you.
Akshat, I can leave?